Charlie Brown, National Council Consumers for Dental Choice. Our mission is to ban the use of mercury-based dental fillings, known incorrectly as silver fillings. FDA considered amalgam to be grandfathered. The head of the Center for Devices testified before Congressman Burton's committee in 2002 when asked, would amalgam be approved today? He said, I don't know. He said, I've thought about that, and the answer is, I don't know. Meaning he isn't sure that it could have been approved under the prove it safe first. And of course, it could not be proved safe. And FDA acknowledges that. It's certainly, even they admit it can't be proved safe for children under 6, pregnant women, nursing mothers. They never classified the capsule, and they admitted they hadn't classified it. They admitted to the court when we sued them, and their answer was always, we're working on it, we're working on it. And when they were sued mandamus in the mid-90s, it was, we're working on it. So FDA's lead on this is a dentist who is an incredible advocate of amalgam, very close ties to organized dentistry, Susan Runner. No science training at all, she's just a dentist. She has been the lead advocate, and she's been able to get everybody to rubber stamp it. And when FDA makes a different decision, she sabotages it, and everybody in the agency doesn't mind. We sought a court order to order FDA to classify. So that's what our 2007 case, filed at the end of 2007, served in early 2008, was about. FDA simply deciding not to classify, to leave amalgam on the market as an unclassified product. It was outrageous, but that was FDA's decision. They simply didn't care enough to classify the product, the device. We had a wide assortment of plaintiffs because standing in federal cases for nonprofits and individuals is very tough when you sue the government. So for nonprofit groups and consumers to get standing is difficult. So we put together a wide variety, 4 different kinds of nonprofit groups, including Consumers for Dental Choice. The lead was Moms Against Mercury, perfect name for the case. 2 public officials, injured dentist, dental worker, and consumers, and proceeded. And the judge, to our delight, when the government said they don't have standing, and that's what the government always says if this group doesn't have standing, who does? Our motion was to take it off the market until they classified it. We didn't think we'd win that, but it was a procedural tactic to get the issue in front of the judge now rather than at a trial. Judge Ellen Hovell said, that's enough. You go into mediation, you come back here a week from Monday, and you tell me what date you're going to classify amalgam. Said that to FDA. So that she realized it was a game, and she said these people are entitled, these plaintiffs, my clients were entitled to have a date by which they would classify amalgam. So I said that to FDA. Can you give us warnings? This is the phone call before the actual mediation. They said, we can't give you warnings. That's too complicated. Like classifying takes a long time. And they said, in fact, classifying is going to take so long, you're not going to go along with it. But that's how long it's going to take. They convinced me it was reasonable. But the horse trade was they were going to have to change their website. I said, well, then you give us warnings. We can't do warnings. I said, can you give us warnings and not call them warnings? They said, yeah, we can do that. We'll put them on our website. How about the website? Fine. I said, so they agreed to rewrite their website. And that was the other part of the mediations, was they would rewrite their website, put warnings on their website, which they didn't call warnings, but they were on the website, so everybody would think they're warnings, their consumer website. So we had FDA, in settling, agreed to put 2 things, put up the website and classify on a date certain. They said they needed a year. I think they did. There's a lot of things you have to do to write a rule. The judge ruled that I got more in the settlement than I could have won at a trial. Now that's highly unusual because a settlement is supposed to be less than, you with the risk at trials, you generally get less if you settle. She said I got more because I got this change in website.